State them.
I can hear you. Can you hear me?
Are we active on YouTube again or not?
You should, if it should be on, Your Honor.
Yes, we're live, Judge.
Okay. Back on the record on cause 980 to the Texas versus Gabriel Calvillo. Mr. Calvillo, after our hearing, we had a conversation. All parties present where you voiced the concern that you might not want to go through with this plea at this time. And you and your attorney were sent to a chat room so that y'all could confer in private about that. I need to know from you on the record whether or not you want to continue with the plea that you've already entered and the punishment you've already received, or you want to start over. What do you want to do, sir?
No, we'll just go ahead and get it done.
Okay, so at this time, what you're telling me is that you're happy with the plea that you just entered, and you understand you're going to have a conviction for driving while intoxicated first offense, and it's a judgment satisfied case, which means other than the time you've already spent in jail on this case, there'll be no further punishment. And that's okay with you?
Yes, sir.
All right, Mr. Miller, is that your understanding of Mr. Calvillo's position at this time?
Yes, it is, Your Honor.
Okay. I'm going to excuse Mr. Calvillo, unless Tony, you want him to hang around for some reason. And then we'll take up Tony's MTR case with Mr. Brown here next.
That I will be. I have a phone number for Mr. Calvillo, so I'll be able to communicate with him at any time, Your Honor.
Okay, Mr. Calvillo, we're going to excuse you. Thank you for your participation. And I'm assuming probably tomorrow would be the earliest you can really start getting GPS bracelets and whatnot off. But it'll all be on the computer this afternoon at some point, so they can follow that. Fair enough?
Okay.
That's all. Thank you. Okay. Let's talk about cause number 592209 to the Texas versus Gerald Brown. This is a motion to adjudicate guilt and revoke community supervision. Representing Mr. Brown is Mr. Tony Miller. Representing the state is Mr. Nicholas Maru. Representing the Bexar County CSCD is Ms. Susan Gross, who I remind is still under oath. This is an uncontested motion to revoke probation. At this time, Mr. Brown and Mr. Miller, I'm holding in front of you two documents. The first one is entitled Defendant's Consent to MTR Hearing by Video Conference, which is purportedly signed both by Mr. Brown and his attorney, Mr. Miller. Is this your signature on this document, Mr. Brown?
Yes, sir.
Thank you. And is this your signature on this document, Mr. Miller?
Yes, it is, Your Honor.
Next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, where it is marked, and it should be marked that this is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right to appeal. So if that's not marked on the original like that, that's what it needs to be. Is this your signature on this document, Mr. Brown?
Yes, sir.
And is this your document on the signature? Is your signature on this document, Mr. Miller?
Yes, it is, Your Honor.
Okay. Mr. Brown, on the second amended motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
No contest.
Would that be true?
True. I mean, yes, sir.
And Mr. Miller, that's your understanding of Mr. Brown's correct plea, is that correct?
That is correct, Your Honor.
Okay, Ms. Gross, would you please advise all parties of the status of Mr. Brown's probation?
Yes, Your Honor. Mr. Brown's reporting has been very poor in that he has missed the last 4 months of probation. The last time that we saw him was November the 5th, and his case is paid in full. He only completed 15 of his 80 hours of community service. He did complete the stress education and the drug offender education program. However, he had a total of 7 positive drug tests and 4 negatives. His positives were 5 for marijuana and 2 for benzodiazepines. The probation department is requesting that this case be revoked. And for the court's reminder, this case did expire on March 25th of 2020. And his criminal history, he has prior arrests for evading arrest or detention. He was sentenced to prison on a theft $2,500 to $30,000, theft $100 to $750. He's currently on probation for robbery. He has a prior arrest for engaging in organized crime and a possession of marijuana, which I believe was taken into consideration with this case at sentencing.
What's the department's recommendation is revocation, is that correct?
Yes, Your Honor.
Recommendation on Mr. Brown's case?
Yes, Judge. So the state is going along with Judge Stahl out of the 175th, and their probation just recently placed Mr. Brown on house arrest, and he's been on house arrest since September. He tested positive for those marijuanas, but since then we've been seeing a decrease in the amount of THC that's actually in his system. So going along with what the felony has done with his probation on the robbery, we were going to recommend continuing him and requiring weekly UAs for at least 30 days and zero tolerance.
How are we going to get weekly UAs if he doesn't show up? We haven't seen him in 4 months.
And in addition to that, his case is expired.
Judge, the only thing I will bring to the court's attention is that I spoke with the felony prosecutor, Clint Malloy. The agreement was reached in the 175th, Judge. They asked me to contact your court. I did. I believe I spoke to both you and Mr. Maru regarding this issue, and the court had advised me that if Mr. Maru was in agreement with what was being done in the 175th, that the court would also go along with that.
This is Amir.
Hi, it's Monica. I'm returning your call.
I left you a voicemail with the new date. I think it's March
Mr.
21st.
Mamori,
Check your
Mr.
voicemail.
Amir,
Hold on. Yes, Judge, hold on.
Mute your, there you go.
I'm sorry, Your Honor, but again, back on September 16th, I believe I communicated with the court, with Mr. Maru, with the 175th, and this particular issue was done in an effort so that we wouldn't be doing something contrary to what was agreed in the 175th, where he was continued on probation there. I know from speaking with Mr. Clint Malloy, the assistant prosecutor in the 175th, he also had communication with Mr. Maru, and I believe this agreement was reached in regards to that issue. The court has had Mr. Brown under house arrest since June 26th. It was on September 23rd that the 175th wanted him under full GPS house arrest for an additional 60 days, which would essentially be up on November 23rd, Judge. And then from there, he was going to be under certain conditions in the felony prosecution case, which I believe also was zero tolerance and things of that nature, Judge. So we tried to address all of this in advance prior to having this hearing here today.
Let me back up a second. What specific crime is Mr. Brown on probation for in the 175th now? Is this the
Robbery.
Robbery, Your Honor.
colorful? Okay. And Mr. Miller, you would agree with the court probably that the court is not bound by any agreement you may have with the district attorney's office or the felony judge or the felony prosecutor. Is that correct?
That is correct, Your Honor. I understand those things. I would like to bring to the court's attention, Your Honor, also that Mr. Brown is going in for UAs, so he is meeting those obligations right now. So as far as reporting purposes, I don't see where that would be problematic because he is currently going in. They do give him permission to go in and take those tests.
Ms. Gross, aside from the various positives for different drugs that occurred during Mr. Brown's probation period, what did he actually do on our probation, if anything?
Judge, he did successfully complete his stress class and the drug offender education program, which appears not to have helped him at all. And he only completed 15 of his 80 hours of community service, and he did pay in full. If the court is considering, going along with the felony court, we would, at the minimum, request a reform judgment that he be revoked off of his deferred sentence and placed on regular probation, or sentence him on this case as a straight revocation and allow him to serve his sentence on house arrest while he's serving his felony time at home. Again, because this case did expire back in March.
Brown, the court accepts your plea of truth, all conditions on the motion to revoke probation with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty, defense of unlawfully carrying a handgun. I sentence you to 6 months in the Bexar County Jail instead of the year I could have. $4,000 fine plus court cost, credit for time served, time and money to run concurrent. This case to run concurrent with 2018 CR 32698 as an alpha. Defendant to report to the Bexar County Jail at 9:00 a.m. on Monday, November 16th, 2020, to give him time to get his affairs in order. If the felony court judge were willing to allow Mr. Brown to go to SATA, Substance Abuse Treatment Facility, or MIOF, Mental Illness Offender Facility, for drug treatment, the court would be happy to run his jail sentence CC with whatever time he stays in inpatient drug or alcohol rehab. Any questions, Mr. Miller?
No, Your Honor.
Let Mr. Brown. Okay, we're ready on Mr. Gerson Uriel Alvarez Segura. That'd be Mr.
Yes,
Vargas.
Your Honor.
This is
Jesus Vargas here for Mr. Alvarez Segura.
This is cause number 6000611, State of Texas versus Gerson Uriel Alvarez Segura, as represented by Mr. Jesus Vargas, representing the state of the Assistant Criminal District Attorney is Mr. Nicholas Maru, representing the Bexar County CSED is Ms. Susan Gross, for our mind is still under oath. This is a motion to adjudicate, motion to enter adjudication of guilt and revoke community supervision. This is an uncontested motion to revoke probation. How does the defendant plead?
Your Honor, he pleads true to condition 2 and 9.
And I got ahead of myself, and I apologize. I neglected to have y'all identify some of our documents in this case. The first document I request to have y'all identify and authenticate a document entitled Defendant's Consent to MTR Hearing by Video Conference, which reports to have both Mr. Segura and Mr. Vargas signatures on it. Is this your signature on this document, Mr. Segura? Can you hear me, Mr. Segura? Is Mr.
I don't know
Segura?
if he, did you want? Yeah, he's on there, but he's not, he's still on mute.
Hey, Mr. Segura, your microphone is turned off. You'll have to look around on your screen for the turn it back on, unmute button. There you go. Can you hear me, Mr. Segura? Mr. Segura, can you hear me?
He is not showing that he is mute.
We can't hear you, Mr. Segura.
I did not hear that well, Your Honor.
You're good, thank you. Is this your
I
signature?
hear you a little bit broken, Your Honor.
All right, let us know if there's a problem with communication. Is this your signature on this document entitled Defendant's Consent to MTR Hearing by Video Conference? Can you understand what I'm saying, sir?
I can hear you way better, Your Honor.
Okay. I'm looking at a document entitled Defendant's Consent
Yes, I can hear you.
Video Conference that's supposed to have your signature and your attorney, Mr. Vargas' signature. Is this your signature on this document, sir?
I can hear y'all, but I cannot see any.
I don't understand what's going on with the communications, but I'm getting broken.
I don't see any paperwork. I only see, yeah, that's my signature, yes.
Try now, Mr.
Yes. Yes.
Can you hear me? All right, good. Mr. Vargas, is your signature on this document, sir?
Yes, it is, Your Honor. And for the record, Mr. Almarez Segura did come by my office and sign defense consent to a MTR hearing by video conference on top of the one online, just to be
Yes.
up to.
Yes.
Mhm.
All right, I'm now looking at a document entitled Trial Court Certification of Defendant's Right of Appeal, and my document copy is blurry. But
Hello?
it should be marked is a revocation of the defendant's community supervision. Let's see, no, this is a motion adjudicated, not. Yes, I'm sorry. It should be marked is an adjudication of guilt
Hello?
for adjudication, and the defendant has a limited right of appeal.
I can hear you.
Mr. Alvarez, can you hear me now? Can you hear me now? Then we have a problem. So you got any ideas on how we can fix this?
I have no idea, Your Honor, what's going on with it.
Maybe sign out, sign back in.
Yeah, maybe he needs to sign in, back out and signs back in. Maybe that would help.
Mr. Alvarez, can you hear what we're saying now? You have to say yes for me. I can see you nodding your head. If you can hear me, please say yes, I can hear you.
You need to speak, sir.
Yes, I can, sir.
Does Mr. Alvarez speak English?
Yes, he does, Your Honor.
Okay, so
Yes, Your Honor, I can hear you.
Mr. Alvarez, I'm still having a problem hearing you. You're giving me.
I can hear you.
Okay, Mr. Alvarez, do me a favor. Let's have you sign out and sign back in. Do you have all the little numbers, or do you want to write them down? I can give them to you right now on how to do that. Okay, I don't speak sign language.
Yes, I can hear you.
All right. Do you have the numbers to sign in again on Zoom? Yes? Say something.
Okay.
Alvarez. Let's stretch the microphone.
Yes, I can hear you.
All right, let's try to continue.
I'm speaking. Yes, I can hear.
All right, let's try to continue then. So, Mr. Alvarez, on the document entitled Trial Court Certification.
Yes, can y'all hear me?
Judge, this isn't gonna work.
All right.
No, I can't hear you. It's okay.
You can hear me, correct? Yes?
He's lagged, Judge. He's hearing whatever you're saying, like 15 to 30 seconds.
All right.
You've actually said it.
No, it's okay. I'll be right back. Let's go ahead and sign out.
Mr. Alvarez, go ahead and sign out and sign back in. Do you have the right numbers to do that?
Your Honor, there is a phone line. He can phone in and be on the video and stuff. If he calls.
Okay,
phone line.
a phone line, he can call me.
He can call into the phone line that's attached to the invitation Pat sent. There's an actual phone line, so you can, when you have hearing problems, you can use your own phone for that.
Okay.
purpose.
Oh, he's gonna
Just
sign.
because I've been doing Zoom every hour of every day, at least.
Okay.
I think he's on Zoom on his cell phone too. I don't know if that would still work.
Mr. Alvarez, can you hear us now?
And on phone at the same time.
Okay.
You can call in that number. Because the phone, it's an iPhone or an Android?
It's a
You can
number
call in
to
that
call.
number and
You
have
have
it
that.
Okay.
phone.
Mr. Vargas,
He's gone.
okay, he left. Now maybe
Probably-
he's gonna
Oh.
sign back in.
Yes, that's what I text him to sign out and sign back in. So maybe that's what he's doing.
Okay, never, he left.
What's the number that he can call in?
It's on the bottom of the invitation.
Within the email Pat sent us.
I'm gonna look for the phone number.
Yeah,
It should be
I got a Houston number on there.
Do you see the number?
It's, if it's a Houston number, I have 346-248-7799. Is that the number he's supposed to call in? If,
That's only for Houston people. So use the
Oh,
American
okay.
and then, yeah.
I don't have any.
Hello?
Hey, Mr. Alvarez, I'm back, are you?
Judge, I can hear you now. Can you hear me?
Yes, I can. All right, let's try this again. Mr. Alvarez Segura, I'm holding in front of you a document entitled Trial Court Certification of Defendant's Right of Appeal. That's marked that this is a revocation of the defendant's community supervision. No, I'm sorry. Is marked that it is a adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document, sir? Can you hear me this time, Mr.
Yes,
Alvarez?
Your Honor, it is.
It is your signature. And Mr. Vargas, this is your signature as attorney for Mr. Alvarez.
Yes, it is, Your Honor.
All right. On the motion to enter adjudication of guilt and revoke community supervision, my understanding is that Mr. Alvarez Segura is entering a plea of true with an explanation to number 2 and number 9. Would that be correct, Mr. Vargas?
Yes, Your Honor.
Ms. Gross, what's the status of Mr. Alvarez Segura's probation at this time?
Judge, his reporting has been good. We last saw him on November the 6th of 2020. He has paid in full. He has completed all 60 hours of his community service. He has completed DWI education, victim impact panel, and CATSNP. He also completed his Smart Start mobile term on April the 14th of 2020. He did have a no arrest for a DWI, but that was dismissed. And the officer is asking that if the court chooses to continue him on probation, that he be placed in the intensive outpatient program and that he be put on Smart Start mobile for the duration of probation.
A recommendation?
Along with probation, Judge.
And his only other arrest was in evading the DWI that's on the motion that was dismissed.
Okay. So basically what we're dealing with is someone who is doing well on probation right up to the point where they consumed alcoholic beverages and then failed to report an arrest, but that arrest has been dismissed. Is that kind of where we're at?
Yeah, that arrest has been dismissed, Judge.
Okay.
Yes.
How
Yes,
much
Your Honor.
time does Mr. Alvarez Segura have on his probation period?
He is due to expire on January the 28th of 2021.
Is he currently on a Smart Start mobile device?
No, Your Honor, he completed that on April 14th of 2020.
Was he on a Smart Start mobile device when he allegedly consumed alcohol on or about?
No, Judge, that was the issue. No,
Yeah.
that was the issue. As soon as he got off Smart Start, that's when this happened.
And I think he's back on it after he was
He is
charged
back
with
on it now, I believe, Judge.
Okay. Mr. Alvarez Segura, the court accepts your plea of true to conditions 2 and 9 with an explanation. I deny the state's motion to revoke your deferred adjudication probation or to continue on deferred adjudication probation with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary, sir? No? Okay, good answer. Adding Smart Start mobile device within 10 days at 6 blows a day. Once he shows us that he's doing well on the device, if he shows me a 30-day,
Your Honor.
thank you. If he shows us a 30-day period of time without any high bracs for alcohol and without missing any tests, we'll crank him back down to 4 blows a day. If he continues to do well, defendant is welcome to approach the court with the request to remove it again. At this point in time, I'm not inclined to do that. Anything further from the state of the defense on Mr. Alvarez Segura?
No, Your Honor.
Good luck, Mr. Alvarez Segura. Thank you, counsel.
Don't go anywhere
Thank
yet. Don't go anywhere. All right, Mr. Segura. As soon as you are done here and done conferring with your attorney, your officer will be emailing you sometime tomorrow a copy of new conditions which you need to sign and return. Okay? Are you currently testing 4 or 6 times?
6 times if I'm not mistaken.
Okay, all right. So nothing will change, but you will still need to sign conditions showing that you are
Okay.
up to do it here on your current probation case. Do you have any
Uh,
questions?
6 times a day.
Okay.
Yes.
First, I have a question. Did we
Yes.
have Mr. Alvarez Segura on pretrial supervision with a SmartCart mobile device? Did we put it on in there somewhere? So right now he has one on or not?
No.
He says that he has one now. I was just looking at his last reports, and I show that he obtained a Smart Start back in June.
Yes, I do, Your Honor. I have mobile right now.
I think,
Today, back in June till the present,
Yes.
we haven't had any violations or hyper since then?
Let me review. It'll take me just a minute, Judge.
I did ask my client that question. He said he has not.
The point I'm making is if he's already showed me 30 days at 6 blows a day without having a violation, I'm just going to make him do 4 blows a day now. I'm not going to make him do 6 again if he's already done it.
Yes, Your Honor.
Judge, I do see a few skip tests here and there. But thus far, I got 2 more reports to look at. Thus far, I do not see any alcohol violations.
Put him back at Smart Start Mobile. Well, he's already on it, I guess. Continue Smart Start Mobile. Let's reduce to 4 blows a day. If we have any future problems, we'll talk again.
Yes, Your Honor. All right, Mr. Segura, you're still going to receive paperwork from your officer. It will show that you're going to be testing 4 times a day. If you do not hear from your officer by like 3 o'clock tomorrow, you need to reach out to your officer. That is your responsibility. Do you understand? All right.
All right. Good luck, Mr. Alvarez Segura. Thank you, Mr. Vargas. Y'all are.
Thank you, Your Honor. Thank you, Your Honor.
We ready on State of Texas versus Michael Rodriguez, cause number 596276.
Yes, I do. Thank you.
Okay.
Yes, Your Honor.
This is cause number 596276, State of Texas versus Michael Rodriguez. This is a motion to enter adjudication of guilt and revoke community supervision. Representing Mr. Rodriguez is Judge Joanne De Hoyos. Representing the state is Mr. Nicholas Maru. Representing the Bexar County CSED is Ms. Susan Gross, who I remind is still under oath. This is an uncontested motion to revoke probation.
Your Honor, may I say something prior to you continuing so I can get it on the record?
Sure.
I did advise my client of the nature that he could plead true or fight the issues. We have a recommendation for the court, and I also advised him that you do not have to follow that recommendation. So he's fully aware of that. Mr. Rodriguez, is that correct? Mr. Rodriguez?
You're on mute, Mr. Rodriguez.
See, I can't see the whole gallery, so I can't see.
Oh, there you go. Mr. Rodriguez, can you hear us now?
Yes, sir.
Go ahead, Judge.
Did you understand what I just admonished you, that you have a right to have a contested hearing? And even though we have a recommendation from the probation department, the judge does not have to follow that. Are you aware of that?
Yes, ma'am.
Okay. Yeah, at this time I feel comfortable. You understand that because of pandemic, the Court of Criminal Appeals, the Supreme Court of Texas have made provisions that we do this by Zoom, and you're comfortable with that. Is that correct? In other words, you don't have to come into the courtroom. You have to answer yes or no. Are you aware of that?
Yeah. Yes, ma'am.
And we send you
Yes, ma'am.
Adobe signed documents the judge has in front of him that waives your right to have the hearing in person. Do you understand that?
Yes, ma'am.
All right, Your Honor, I feel comfortable that we can continue then.
Okay, Mr. Rodriguez, I'm holding in front of you 2 documents at this time. One is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purportedly has your signature and the signature of your attorney, Judge De Hoyos. Is this your signature on this document, sir?
Yes, sir.
Is this your signature on this document, Judge De Hoyos?
Yes, Your Honor.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal. Should be marked an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal, unquote. My document copy is not so marked. Ms. Benavides, that needs to be marked on the original copy before this gets processed. Mr. Rodriguez, is this your signature on this document?
Yes, sir.
And Judge De Hoyos, with your signature.
Your Honor, for the record, I did explain that it was a deferred and he had limited right of appeal. So I did explain that to him prior to his signature.
Is this your signature on this document, Judge De Hoyos?
It is, Your Honor.
All right. On the motion to enter adjudication of guilt and revoke community supervision, Mr. Rodriguez, how do you plead, sir?
True.
All right. Ms. Gross, would you please advise the party of Mr. Rodriguez probation?
Yes, Your Honor. Mr. Rodriguez is reported very poorly. We last saw him on October the 8th of 2020. However, he failed to report during the months of January, February, March, April, and May of 2020. He has completed all 48 hours of his. He has paid $20 towards his fees. He has a balance of $809. He did complete his drug offender education program. He's had a total of 3 positive drug tests, which were all on one occasion, but that one test came up positive for marijuana, benzodiazepines, and opiates. And then he's had 4 negative drug tests. And the case did expire October 6th of this year, and he has 1 prior arrest for 50 to 500. The probation department is requesting that he be extended for a period of 1 year and order him into the CATSNP program.
And state recommendation?
Along with probation, Judge.
Do we have any idea when we're talking about opiates, what specific drug we're talking about when we're talking about opiate? Your analysis?
No, Your Honor.
No, no, dear.
What else do y'all have any clue as what we're talking about?
I did not ask that question. I'm sorry, of my client, Your Honor. I'm sorry. You can ask him, I guess. I don't know.
Is Mr. Rodriguez interested in going to inpatient rehab at the substance abuse treatment facility?
Your Honor, right, we sent you documents to show that he is now in CPS jurisdiction, and he has been working this time in negative drug testing because he is now advocating for his child. So I don't think he can actually go into any lockdown facility. He now knows that he's at risk. He goes into his child. So we were asking if you want to do intensive. He has been on bond since June 29 working. We sent documents to your email, all his proof of paychecks and his CPS and training classes and therapy he's going through now.
All right, Ms. Gross, is the substance abuse facility accepting inpatient defendants at this time?
Yes, Your Honor, they are.
Approximate wait time would be before someone would be admitted after their medical evaluation?
They have to go in for a 2-week quarantine for the COVID testing, and then they'll get cleared medically. And so it's taking anywhere from 3 to 4 weeks to get them actually out to the facility.
All right, Judge Joanne, I apologize. I didn't understand your answer. What you're telling me is Mr. Rodriguez volunteers for outpatient treatment, but he does not volunteer for inpatient treatment. Is that accurate?
Yes, because of his CPS case, he cannot, the child is dependent on him. That's how we send you documents. He has been working. He has been on bond since June 29th of 2020. This happened last year in October, the positive test, November, sorry, right after being put on probation. Since I have been his attorney, I have informed him that you have the ability to put him away for 1 year. And since I met him right before when I was appointed during COVID, he has turned his life around. He has a child. CPS is working with him for therapy, and he will try to take any drug test. I've informed him 1 positive drug test from now on. You can put him back in inpatient. He's fully aware. That's what we're extending for a year so that you would have a year over him to show you that he is saving himself and his child.
Ms. Gross, what specific type of drug did Mr. Rodriguez have in his possession that this case is based on? Do we know?
That's a DA question, Judge.
Yeah, I wouldn't know. I wasn't his attorney.
Mr. Maru, would you have any idea?
Judge, I could pull the offense report if you want.
I can ask my client. Mr. Rodriguez, what did they charge you with? Do you remember what drug?
It was for Vicodin.
Okay. And I believe, and deposit, were you still taking Vicodin in November, about 3-4 weeks after pleading?
No, ma'am.
So what was the opiate then?
I believe it was the Tylenol.
I can't hear him, Your Honor. I think he's losing service.
I think what he said was Tylenol with codeine, but I could be wrong. We might want to see. Yeah.
Rodriguez, can you hear us? Because we could not hear your answer.
Oh, a Tylenol 4.
Okay.
Tylenol 4.
Okay, Mr. Rodriguez, the court accepts your plea of conditions on the motion to revoke probation with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of possession of controlled substance, penalty group 3, less than 28 grams. I sentence you to 6 months in the Bexar County Jail, assess a $2,000 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. on Monday, November 16th, 2020. If you change
November 16th, I couldn't hear you. November 16th?
November 16th is a Monday, is it not?
Okay, good. No, right, good. I just wasn't sure. Okay.
Anyway, if in the interim period of time before Monday, if he decides he'd rather volunteer to go to inpatient for 120 days at the substance abuse treatment facility, I'll be happy to change my judgment. Anything?
I couldn't hear you, Your Honor. I can't hear
Can
you.
hear the sentence, Your Honor.
Okay, how about now, Mr. Rodriguez? Can you hear me?
Yes, sir.
All right. What I'm telling you and your attorney is that you're being sentenced to 6 months in jail. I had the authority to sentence you to a year in jail, but you've done some good things on your probation I'm giving you credit for. So that being said, I gave you the opportunity to volunteer to go to inpatient drug alcohol rehab for 120 days at our substance abuse treatment facility here in Bexar County. My problem is I'm dealing with 1, 2, 3, 4 at least different kinds of drugs. You're a veritable drugstore. And my position is that you need some sort of ability to change the way you think about the use of drugs, or you have to be punished for it. You chose to be punished, so I gave you the nicest possible time I could do and still punish you. If you change your mind before Monday and would rather go to inpatient drug alcohol rehab for 120 days, I can change my order and we can go do that. But I'm leaving that between you and your attorney. You'll have to let us know. Fair enough?
Yes, sir.
Thank you. Anything further from the state of the defense on Mr. Rodriguez?
No, Judge.
Good luck.
Judge, would you clarify the fine, please? There was a garble. Judge, we can't hear you.
Can't hear you, Your Honor.
Okay. Who was it that said the last thing? Judge Joanne, did you say something else?
No, that was me. I need to know what the fine was because there was a distortion.
6 months in jail, $2,000 fine.
3,000? 2. Thank you.
2, right?
Yes, 2,000.
I wrote down 2. Okay, fine. All right, thank you. Can I be excused?
Are we ready on Tiffany Vasquez? Are we getting Mr. Young on? Mr. Young. Is Ms. Vasquez here? Young, can you hear me? Wayne, can you hear me?
Yes, sir.
Okay. This is cause number 616373, State of Texas versus Tiffany Vasquez. This is a motion for probation. Ms. Vasquez, representing the state is Mr. Nick Maru. Representing the Bexar County CSCD is Mr. Rose. I remind us under oath. Representing Ms. Vasquez is Mr. Wayne Young. Ms. Vasquez and Mr. Young, I'm holding in front of you 2 documents. One entitled Defendant's Consent to MTR Hearing by Video Conference that purport to have your signatures on it. Ms. Vasquez, is this your signature on this document, ma'am?
Yes, Your Honor.
And Mr. Young, is your signature on this document? Mr. Young, is this your signature on this document, sir?
I can't see it, but I did sign one, Judge.
Okay. On the document copy I have, the date underneath Mr. Young's signature is not put on this document. So before it gets processed, the date of November the 9th needs to be on the spot, Pat. Okay. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal. And it is marked application of the defendant's community supervision. The defendant has the right to appeal the action revoking the community supervision without the underlying conviction. Ms. Vasquez, is this your signature on this document, ma'am?
Yes, Your Honor.
And Mr. Young, is this your signature on this?
Yes, Your Honor.
All right, this is a second amended motion to revoke supervision. It is uncontested. The defendant.
Judge, you keep going in and out all the time.
All right, this is what's going to happen. The only person that doesn't need to have their microphone off of mute is Judge. If you are not being addressed, put your microphone on mute. As soon as he addresses you, take it off of mute, answer the question, put it back on mute. But unless you're being spoken to, please put your microphone on mute. Anyone, that's everyone.
Okay, well done. On the second amended motion to revoke community supervision, how does Ms. Vasquez plead?
Guilty, Your Honor. Oh, no contest.
All right,
Can I say something?
allegations true? Are these allegations true, Ms. Vasquez?
Is this for the, which one is this for, Your Honor?
Simply true that these allegations they've made against you are true or not true, meaning that again, are they true or not true?
Not true.
They're not true?
That's, is that for the motion to revoke, Your Honor?
This is a motion for revoke. All right, Mr. Young, I'm in here somewhere. Y'all have the ability to plead not true and go to me as a trier of fact to make a decision, or you have the ability to ask for a fully contested motion to revoke probation, but I'm not sure you're going to get any more witnesses than Ms. Gross anyway on that one. So I'm still confused as to what Ms. Vasquez plea is. If it's not true, you're welcome to do that, and we'll continue with the hearing, and you will both agree that you're come to me for a decision on the case, or you can back up a minute and plead not true and request a fully contested motion to revoke probation. What would y'all like to do, Mr. Young? And if you need time to go in a chat room and chat with Ms. Vasquez, you're welcome to do that also.
Can you hear me?
I got you.
Judge, I had met with ADA and we had agreed that we would terminate this on set. Her probation has expired.
Let me look at something for a second. Go ahead and clarify for me what we're doing on the plea before we get into a possible plea bargain situation.
We're pleading on it, Your Honor.
All right, are you going to plead true or not true?
We'll plead true on it.
All right, is that correct, Ms. Vasquez? That's okay with you?
Yes, Your Honor.
All right. Ms. Gross, please advise the parties and the defendant of the status of Ms. Vasquez's probation, please.
Judge, Ms. Vasquez has reported as directed while on probation. She only missed 1 month when we last saw her on November 3rd of 2020. Her case is paid in full. She has completed all 48 hours of community service, as well as the DWI Education Victim Impact Panel, CAP-SNP, and stress programs. She also completed a stint on the Smart Start mobile device on February 10th of 2020. She has had 2 positive drug tests, 2 for marijuana, 5 diluted drug tests, 1 failure to submit, and 3 negatives. She does have 2 prior arrests, 1 for assault bodily injury and a 2nd arrest for assault bodily injury married. Her term did expire on July the 1st of 2020, and we are recommending that her probation be terminated unsatisfactory.
All right, make sure I'm clear on this. She has 5 tests, is that correct?
5 diluted, 2 positives for marijuana, and 1 failure to submit, and 3 negatives.
Mr. Young, I'm not inclined to go along with the agreement that you tentatively have with the state, but I am inclined to revoke her and give her a judgment satisfied verdict with her 5 days in Bexar County Jail on her record. Would that be agreeable to the defense?
Would that be 5 days that she has to serve, Judge, or can she have credit for any time she has?
Got credit for 5 days, so I would probably give her 15 days, 3 for 1, credit for time served, judgment satisfied. She would be completely done with anything else on this probation.
That would be fine with me if my client says it's okay, Your Honor.
Vasquez, would that be all right with you?
Yes, Your Honor.
Ms. Vasquez, the court accepts your plea of true to all conditions on the motion to revoke community supervision. I grant the state's motion to revoke your community supervision. I sentence you to 15 days in the Bexar County Jail. Susan, what was the original fine amount on this case?
It was, hang on, Judge. Judge, the original fine was a total of $600.
I sentence you to 15 days in the Bexar County Jail. It says a fine of $600 plus court cost, credit for time served, time and money to run concurrent, judgment satisfied.
Your Honor.
Anything further from the state?
No, Judge.
Anything further from the defense?
No, Your Honor.
Good luck, Ms. Vasquez. Thank you, Mr. Young.
Judge, I believe she has an active warrant.
Oh, recall everything bad that we did before today. So recall warrants, GPS, Graham, whatever bad things we did will be recalled as of this afternoon. All right, anything further from the state or the defense on Ms. Vasquez? Warrants, GPS.
No, Judge.
No, Your Honor.
No, Your Honor.
Okay, ready on Eric De La Cruz? We got Mr. Memori, we got Mr. De La Cruz. Can you hear me? Mr. De La Cruz, your microphone is off, sir.
Yes, sir.
Can you hear me now, Mr. De La Cruz?
Yes, Your Honor.
Thank you, sir. This is cause number 613196, State of Texas versus Eric De La Cruz. This is a motion to revoke community supervision. Representing Mr. De La Cruz is Mr. Rahim Memori. Representing the state is ADA, Mr. Nicholas Maru. Representing the Bexar County CSCD is Ms. Susan Gross, who I remind is still under oath. Mr. De La Cruz, I have 2 documents for you to identify for me. One is entitled Defendant's Consent to MTR Hearing by Video Conference, which purports to have your signature and your attorney's signature on it. Is this your signature on this document, Mr. De La Cruz?
You're muted, sir.
Yes, I signed those.
All right. Mr. Memori, is this your signature on this? Can you hear me, Mr. Memori? We're not hearing you for some reason.
Oh, he's gonna sign back in.
We've never had this much trouble with the Zoom stuff before. I don't know what to do.
I think everybody and their brother is on the internet.
Judge, I'm back.
Much better.
Yeah.
All right. So with regard to the document entitled Defendant's Consent to MTR Hearing by Video Conference, Mr.
Judge, that is my signature, yes.
Okay. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, where it is marked that it is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. And Mr. De La Cruz, is this your signature on this document, sir?
See the paperwork, but I did sign the paperwork.
Okay, and is this your signature on this document, Mr. Memori?
It is, Your Honor.
Okay. This is an uncontested motion to revoke community supervision. On the motion to revoke community supervision, how does the defendant plead?
He pleads true, Your Honor.
What's the status of Mr. De La Cruz probation, please?
Judge, his reporting has been very poor in that during the term of his probation, he's missed a total of 4 months. We did last see him on November the 4th of this year. He has paid in full. He's completed all 48 hours of his community service, as well as DWI education, victim impact panel, and the CAT-SNP program. He's had 7 negative drug tests, 2 failure to submits. He was on the Smart Start mobile device, and that was removed on June 3rd of 2020, and he was placed on a Scram device. The last word that I could find in his file is that he is in violation because he hasn't downloaded since September. However, his officer is recommending that he be continued on probation, but he remain on Scram until the end of probation, which is in 10 days on November 19th of 2020. He has 2 prior arrests, a burglary of a building for a felony, and a burglary of a vehicle.
State recommendation, please.
Along with probations, Judge.
Judge, because Mr. De La Cruz is going to expire in 10 days, what is the court planning on doing? Extending him, or will you just leave him on Scram for 10 days and then see how he does?
I'm gonna deny the motion. I'm gonna leave him on just the status he's in and see if he can go 10 days without getting in trouble. Fair enough?
Perfect, Judge. We appreciate your time.
10 days without getting in trouble, Mr. De La Cruz.
Hear from me again.
You're likely to get a UA any time of the day or night, so be prepared.
Yes, sir. I did do the Scram last week, so
So are you on Scram or anything right now?
yes, sir.
All right.
So have you done your download and you're active now?
Yes, I downloaded last week.
Okay, all right.
In that case, to stay on Scram till the end of probation, you can take it off, no hard feelings. Fair enough? Let me be formally on the record. The court accepts De La Cruz.
Excuse me, Your Honor.
All conditions on the motion to revoke probation. I deny the state's motion to revoke his probation. Order him continued on probation with all prior requirements and no sanction at this time. Mr. De La Cruz, stay on your Scram bracelet until this is over, at which point you can take it off. Ms. Gross, anything else we need to do?
No, sir. Mr. De La Cruz, it's going to be just standard operation from here on out. However, you do need to touch base with your officer tomorrow. Let her know what happened, and then you just got to stay out of trouble for the next 10 days.
Yes, ma'am.
Okay, and then after your termination order is signed, then you'll be able to go back to Scram and get your bracelet cut off, okay?
Okay.
All right.
All right, anything further from the state of the defense of Mr. De La Cruz?
That's it, Judge.
Good luck, Mr. De La Cruz. Thank you, Mr.
Judge, from us, I'd like to thank Pat for her time for organizing this, and for Ms. Gross for her time, and Judge also for the prosecutor and your time.
Thank you so much.
Thank you.
Thank you.
Thank you. Good to see you. Bye-bye.